Namaskar, everyone. Welcome to our new episode of this channel, So You Soon. We have this endeavor that through this program, we try to bring guests to you from all over the world and from across the country, especially from the legal industry and also from other walks of life. And today we have a very, very special guest for all of you, who is not just a legal luminary, but if I may say so, a legal stalwart in our industry. And before he was a lawyer, he was a bureaucrat. And before he was a bureaucrat, he was a scientist. And he has had a very, very interesting journey, which we are going to discuss in our Q&A session series today. And before I go further with the Q&A, I extend a very warm welcome to our Parthasarathy, sir. Sir, thank you so much for taking your time, valuable time, and coming to our program.
Thank you very much, Jayant, for giving me this opportunity. But I don't think I have done anything great, as you have stated. But definitely, I'll share whatever my little experience I have. Please proceed.
So before we start our formal question and answers, we always ask our guest in the program. So please shed some light about your birth, early life education. And we know that you became a lawyer much later. So we'll try to come to that phase a little later. But the early life from your birth, your early education, and what prompted you to pursue science as a career. And then once we have finished that part of your career, we'll then jump to your life in the bureaucracy and thereafter.
Okay. See, I have been born and brought up in Chennai. So I have my early school education and my pre-university at Loyola College in Chennai. And then I shifted for my BSc Honors in Physics to DG Vaishnav College in Chennai, from where I completed my honors in physics with distinction. That was way back in the year 1975. Of course, I was always been interested in science. So whether it is the 10th or at that time, it used to be 11, 1, 3, not the 10 plus 2 system, 11 plus 1 plus 3. There also I had only mathematics, physics, and chemistry as my subjects. And then I majored in physics. And that mainly because I was also, my hobby was a ham radio operator. So I had a license to operate a radio station at my home way back in 1975. Having got the license at that point of time from the Wireless Planning and Coordination Wing of the Ministry of Communications now. So I used to pass an exam, theoretical exam, and also I have to do a Morse code. I could do Morse code transcription and also transmit at more than 12 words per minute at that point of time. So because of all that, I think my interest was in physics, and therefore I graduated and went into physics. And having got, of course, the distinction in physics, I had an offer for MSc in physics from the Indian Institute of Technology at Chennai, or Madras as it used to be called at that time. And also at the Madras Institute of Technology, which is used to be again on the parallels of MIT, Madras Institute, it was very, very prestigious. There also I did get an offer. But my family circumstances such that there was no earning member in the family, so I had to go for a job. So I relinquished both the offers, and I took up a job as a television engineer in a newly set up television company called Dianora Televisions at that time. Then I'm talking about 1975 September, 3rd of September when I joined them. And of course, black and white TVs had just started getting manufactured at that time. And that's how I started my career. That also because of my hobby, physics, and all this background together, I think I landed up at that job. But it was just about 7 or 8 months I stood before I got a job in the Accountant General's office of Tamil Nadu as an auditor. From there, of course, in 1976 itself, I wrote my civil service examination, because having decided that I'm not proceeding for higher studies, at that point of time, the two options for all people were either go as an officer in any bank or you go to the civil service. I think these are the two broad things which are available. So I decided that I'll take up the civil service career. So I wrote the exam in 1976. At that time, again, it was a different pattern. We used to have 3 general subjects, and we used to take 3 lower subjects. And if you want to write IAS exam, you have to write 2 more subjects called higher subjects. So 3 lowers, 2 highers, and 3 general subjects called English, essay, and general studies. That's how it used to be. So I of course, only with a background in physics toward the graduation level, I had to put up a lot of effort in order to proceed further. So that's how I think you can say, after completing my college, and I started straight away working. And then in 1976, I wrote my civil service examination. So that's how the career started. So earlier life is only a graduation and nothing more than that.
It's in I think one of your interviews before, I think just last week with I think the Madras Bar Association, I also heard that you pointed out that before you, I think, cracked bureaucracy, and in every person's life there are lots of ups and downs, and I think underweight was one of the criteria which you mentioned. If you can just highlight that for our viewers, and why I want to highlight this question is because your journey is so inspirational, and there are so many young lawyers and young students who are watching this program, because sometimes they just get demoralized, especially in today's time and when we are surrounded with Corona and other things. And I think this is particularly a question I would like you to answer, so that the youths can draw some inspiration from your journeys, and how one must not take rejection at the face value and still keep trying for the next best possible avenue which is possible to us.
Yeah, in fact, yeah, those are very tough times, I would say. Having written the examination for the IAS, you have to pass in 2 papers for IPS and 3 papers if you want to get into the central civil services. So I had at that time pure mathematics and physics as my subjects, and I had an applied mathematics as my third subject. But obviously they were very tough for a person of graduation level to prepare. But I still qualified for my pure mathematics and physics. So I was interviewed by the UPSC for the Indian Police Service. And you have, of course, there are some specific medical requirements of 45 kilos weight, and you should also have a chest measurement of 80 centimeters or something like that's what I remember. But unfortunately, I think I didn't qualify in them. So I had a rejection on the ground of not meeting that particular criteria. But that was not applicable for other things like civil service, other civil services. There was no minimum weight or anything like that. So that was the first experience when I had in but I was very happy. I thought it was a very difficult exam. Very few people are able to get through, etc. But in my first attempt, having able to get through, and I also got 50% marks in my interview, I still remember, because those are very important developments in your life. You don't forget. You come through a very difficult time. So that's how I got through that exam. But of course, I didn't. So I said, okay, I will take one more exam. By the time I know I have also one more year to prepare very well. And therefore, I said that I'll prepare and write the civil service exam again in 1977. That's how I started. And but in 1977, I also got a job as a management trainee in Steel Authority of India Limited, which again used to be very, very prestigious appointments at that point of time. So the medical examination and the date for joining were clashing with the civil service examination of 1977. And of course, as a youngster, and you have a lot of other well-wishers, people say a bird in the hand is worth 2 in the bush. So when you got this appointment, you should take it up rather than take your chance only with the civil service and leave this the Steel Authority of India appointment. So I couldn't do much because there's so much of pressure on me. So finally, I went to Bokaro Steel Plant for my medical examination. And there, unfortunately, also they had, I didn't know about that at the time, a 45 kilos minimum weight was a requirement, and I didn't qualify by 2 kilos or something, and they rejected me. So I came back from Bokaro. By that time, of course, I lost my opportunity for writing the civil service in 1977. But then by that time, I had written my exams for State Bank of India, Bank of Baroda, National Insurance, all these for probationary officers, and I got an appointment in all of them. And I became an officer in the Bank of Baroda, which came to me first. So I moved to Hyderabad, where I was posted as a probationary officer in 1978 in Bank of Baroda. So from there, of course, I wrote my civil service exam again in 1978. And that was the first time I had I had my pure mathematics, physics, because I was always very comfortable with those subjects. But for the third subject, I found applied mathematics was a little more difficult for me because I was also working. You must know that I've already been working and I'm preparing for the examination. So it was not possible to put in all that effort. And I had a liking, I don't know why, for law. And there used to be 3 subjects of law. And one of them was Mercantile and Company Law, which is Contract Act, Sale of Goods Act, Partnership Act, and Companies Act, all put together was one subject. So I took that in 1978. And I, of course, got through in all of them with a very high mark in that. And my first choice was Indian Audit and Account Service, because I had started my career in the AG's office as an auditor. So I knew what it was. So I opted for that. And that my first choice was given. And therefore, in 1979, I left the bank and went to the Lal Bahadur Shastri National Academy of Administration for my foundation course, and then for further training in the Indian Audit and Account Service. So that's how my career progressed for the first 2-3 years. Yes, there was a rejection because of other issues on IPS, and also at the Steel Authority of India Limited, also weight issue. But of course, it was disheartening. I wouldn't say that it didn't, but somehow it didn't make me sit back and say not do anything. I said, okay, I'll try. It's only for IPS. I'll do for the higher ones, etc. And that is how I. And of course, I didn't have any problem in the medicals when I went for the interview in 1979. That was also, I still remember, it was in Subsidies Hospital at that time, the medical examination. Everybody comes to Delhi for interview. And of course, I got through, and that's how I came to civil service from 1979. Indian Audit and Account Service. Yeah.
Right, sir. I think very wonderfully put that one must not lose hope, especially now that I'm talking to you and reflecting at a 20-year-old young man at that point in time in the mid 70s. And a lot of, as I said, our viewers are in their late teens or early or mid 20s, and I must tell them through the wonderful narrative that you have just told us, please do not lose hope. There are multiple gates and multiple avenues that one must keep harping at, and one must never be shy of hard work. So another thing, sir, I'm aware about you and your personality trait is that you have a photographic memory. And why I say that is that I know that you know the Contract Act at the back of your hand and other statutes also. Just as a matter of curiosity, how can a young lawyer know something by heart? Because not everybody is gifted with such sort of memory or such sort of nature. So we have to put in a lot of hard work. So how do we keep about learning and absorbing all these complicated laws? Because I know this was your first brush with law just before you were going to be a civil servant. But because you chose law as a career and you knew these statutes at the back of your hand, how did this magic happen?
That is, of course, when you prepare for a civil service and you have got a limited subject, what you study, etc., is different. But here, when you are in the when you are in the career also, there are certain areas, I would say, which are your core areas. In those core areas, according to me, you should know that law by heart. That comes only by hard work and practice. Whatever I've heard when I read for Mr. Nani Palkiwala's book, which is edited by Mr. Arvind Datar, etc. You see, one thing you come, whether it is an MS Subbulakshmi or Mr. Abdul Kalam, or where you are talking about Nani Palkiwala or any grades, it is about hard work and how something like a 10,000 hours of hard work, is something like a benchmark. A 10,000 hour thing makes you something great. That's what. It's not easy, of course. 10,000 hours is a lot of time you have to spend on a particular subject. So while you may be dealing with a variety of subjects, but you have to have one or two areas, core areas. And in those core areas, I think you should be able to know the law, according to me, by heart, more by continuously reading and pressing. Every time, as you know, you're also a lawyer. Now, somebody asked me a question on GST. I may know the exact provision, but what we do in the presence of the client, we again open the book, read the entire thing, and then apply. Because every time you read, you may get a different view or a perspective depending on a particular problem posed. Because the problem posed, you look at a new direction of the same legal provision which you have already gone through. Therefore, that constant, going through the books for every case, you don't do only from memory. You also again go through, read the same statute which you are aware of, and that, I think, over a period of time makes you comfortable with everything that is there. That, for example, when I did the customs valuation, which was one of the important topics given to me, or the anti-dumping, which was my starting career as a lawyer outside, I'll come to that later. Obviously, those are a few areas I'm going to constantly work on. Therefore, I knew the law at the back of my head. That is only by, I think, constant reading. And it's not that, of course, there is, according to me, you don't gain anything by saying how absolutely you're able to remember or recollect everything. That's not required. But what is required is, that these are the major provisions, these are the provisions, etc. And broad, most important provisions, you should still be able to recall them at the drop of a hat, as you say, and then you should be able. That also gives a lot of confidence when you're discussing with the client also. So because if you're also discussing the client, he must get a lot of confidence when you're dealing with you. So to some extent, and he comes to you for your expertise. Therefore, demonstrating that you have that expertise, I think adds both value to you and also to the client.
Extremely wonderfully put, sir. I think that gives a lot of clarity both to our audience and to me also as a young budding lawyer in the profession, I would say. So now let me ask you the question about your journey in the bureaucracy. You spent considerable amount of time, I think almost 2 decades in the bureaucracy. So please do tell us how was the journey in the bureaucracy, and also when I ask this question, because normally people who are, we all know about UPSC and it's a very lucrative profession, a career that many people in India aspire to be in. But also I think sometimes people of civil society and the general public have this thing in the back of your head that bureaucrats are not doing anything. So sometimes they say they are not bureaucrats, but they're bureaucrats. So that there's also image which gets a fixer. So one, I would like to know about your journey and how to explain to the people or to the audience through this medium that, look, bureaucrats are not bureaucrats. They're actually hardworking people who are also trying to make positive and practical change in the working modalities, not just for the government, but also for the benefit of the society.
Yeah, I think the one thing I would still say is, like people said, you have come out after 17 years in the civil service without having a pension, and I have come out, etc. But at no point of time I felt my civil service was a waste. And I thought that was one of the best experiences which I had for 17 or 18 years, because I think every job gives a different perspective. And as a civil servant, you also get a very good perspective of how government functions and how you are also important in bringing about change. See, something maybe if you are in a private sector where you have a decision-making capacity, you make the decision and quickly implement something, there may be some difficulties for that when you are talking about the civil service. But just look at the GST. 2017 we have introduced. Now, there are people, all this is introduced by people from the civil service. They've all been at the back. They have been studying the GST laws of various countries and trying to imbibe what is the best in them, learn what are the difficulties from them, and then try to get that. So we had a CGST Act, you have the rules, you have the various forms, the procedures, etc., IGST Act, compensation. So there may be, if people start analyzing as law, I also found they have missed probably this in the drafting. This legislation could have been drafted better, I may say. But you look at it from overall perspective, you see the amount of work which has gone in preparing, for example, the implementation of the CGST. And I'm talking only from putting into place the legal systems. Right. You also had the difficulty of the various GSTIN, as you call it, because you have to have the back integrated computer system at the back, etc., where you are taking other people's help. But the bureaucracy is definitely is very, very capable and had implemented these various acts. Like that, when you migrated from any position to, for example, to VAT law, for the first time from the sales tax to VAT, or now from VAT, central excise and service tax into GST, every such transition which involves very major changes have been implemented by the bureaucracy. And like any other, I think, organization, you have always people who are extremely competent, you have people who are medium, who are people not so good. So you have that, I think, like any other system, you have it in the bureaucracy. But my personal view is, because people interact more with the bureaucracy and come out and share their view, you get the perspective as if the bureaucracy is not probably doing something, which doesn't happen if you are in a small private firm. There may be inefficiencies, but nobody talks about those inefficiencies outside because it doesn't matter. Whereas the government, it becomes very important because it touches the life of people at every level. Therefore, people form that particular opinion. So that is why I've said the 18 years which I have got from that has a lot of impact and has helped me in my next 25 years of profession as a lawyer. So a bureaucracy, in my personal, I think they're extremely competent people and they're doing some excellent work, and a lot of things have been brought in. But then you always have, every time, despite all that, there will always be some problems in the law, or the problems are invented by us as lawyers. There are interpretation issues by various. So you can see There is a district court has a view. The High Court single bench is opposite. The division bench another view, and you have the Supreme Court, which means there are possible views are possible. Different views are possible. So if you look at that type of thing, I think bureaucracy has contributed a lot. But everything, yes, there is always scope for improvement, and that you come to know by interacting. When I was in the Ministry of Commerce, I was interacting with all the people who were in the, for example, I was in the gems and jewelry. Therefore, in the diamond and gold trade, I was dealing with a lot of people. I was dealing with deemed exports, which is a very important thing for exporters, etc. And then, of course, in 94, 95, set up the anti-dumping division. So all of them had an impact with reference to people in domestic industry manufacturing, the importers who are affected by, for example, the dumping duty. So you have various economic operators in the country who come to you. And by interaction, they will definitely know, yes, this is a person who will do the best for you. It's possible for him to help, he will help. So the people who interact then come to know how different sets of people operate. And of course, you always have some constraints, not that you can implement something as a director in the ministry, but it has to go up to a joint secretary, or sometimes very important policy changes have to go to the commerce secretary, or for example, the minister, and then get approved. So that sometimes may take time.
Thank you, sir, for that direct answer. If I may also ask, because I think when you joined Audit and Account Services, and your wonderful career spanned for about 17 years with the government, you had a lot of brushes with indirect taxes, custom, excise, etc. How was that learning curve for you before you became a lawyer? And I also know that you are a accomplished company secretary, and also you have done a course in cost accounting. So I would like to ask, and especially a lot of young people want to know that, is it conducive to do so many courses when you're pursuing already a career which is going well for you? Is it important to do these courses? Does it give an additional perspective to gauge things, or is practical exposure within the bureaucracy enough to have a steep learning curve?
Yeah, I think doing cost accounting or company secretary was of my own decision. Okay. In the bureaucracy, when I joined after my honors in physics, I straight away joined Indian Audit and Account Service, and the National Academy of Audit and Accounts, as it is called today, and it used to be called the I&A Staff College, Shimla, at that point of time. We used to get trained in everything, right from economics to cost accounting, general commercial accounting, government accounting, auditing. So all those are the subjects which are taught to us. But the way I felt it, even though for the purpose of doing government audit, it's probably not that you need to be an extraordinary expert like a chartered accountant in the field of accountancy, but knowing the accounting principles, etc., a little more in depth would probably add value to me and also respect. That is how I thought. And having decided that my career is going to be in audit and accounts, I thought a course in cost accounting would be useful. Therefore, I took it up on myself. There was absolutely no requirement, and a lot of people don't do any such courses. I did on my own because I just wanted to know that having that, if I'm doing commercial audit with reference to public sector undertakings. Now, knowing the commercial law and the intricacies of accounting, etc., could probably place me in a better position to do the audit. Second is appreciate the other person's viewpoint. So it is both ways. See, because you know the subject, you will be able to appreciate the other person's point of view and may not pursue a particular audit objection which you have raised with them. So I thought that may do. Therefore, I did on my own the cost accounting course. That was way back in 1982. I got my intermediate, and 83 I did my final, and then I became an associate member, and subsequently I became fellow member of the Institute of Cost and Management Accountants, which I am continuing today. But I think it had helped me at different places, because according to me, no knowledge ever goes waste. Every knowledge comes in handy at some point of time. So I was a rank holder both in the inter and final of the cost accounting examination also. So till about 83, I pursued the ICAA, and that's how I got through. But my legal or tax work, no. I started my career as an assistant accountant general in the Accountant General Tamil Nadu. But in 83, I was promoted as Deputy Accountant General. At that time, I was given the revenue audit. Therefore, and that revenue audit is related to sales tax revenue audit, registration, stamp duty, etc. That is auditing the government of Tamil Nadu, those departments, motor vehicles, etc., how they are doing, how they are implementing the law, whether there are any lacunae. So that was my first brush, you could say, 1983, with revenue audit, tax audit. That's it. And that was hardly a 6-month period by which time I got shifted to Southern Railway. I was a deputy chief auditor for Integral Coach Factory. That gave me a totally different perspective of how to approach a railway production unit, which is under the Ministry of Railways. How and you have so many different facets: mechanical engineering, electrical engineering, civil engineering, signal and telecommunication, all those things, and so many procurements, etc., taking place in the Integral Coach Factory. So that gave me a totally different perspective for about 2 years or so. Then I continued again my revenue audit thing when I was posted to AG Bihar Ranchi. I was posted as a Deputy Accountant General, and then I got promoted as Senior Deputy Accountant General in Ranchi. And that entire 2 years was also only in sales tax and straight revenue audits. I didn't do income tax, I didn't do excise, I didn't do customs at all in my career in the Indian Audit and Account Service. Whatever little I did was only with reference to sales tax revenue audit and state revenue audits. And from there, then after 2 years, I moved to the Indian Audit and Accounts Staff College as a teacher. I was a joint director of the National Academy of Audit and Accounts, where I taught accounting, government accounting, commercial accounting, and various other subjects, which normally the various civil servants who are coming into the service, they are taught. So that is where I think also it gave me a very good perspective on teaching. And I see once you teach, at that time only all the doubts come into your mind, so your preparation and your levels have to be much higher, and especially you're dealing with very bright people who have come into civil service, so they will have a lot of questions. Therefore, that also again enhances your skill set. In between, that is between my cost accounting and before I proceeded to the Shimla as posting, in between, because I got a lot of exemptions as a cost accountant to write the company secretary exam, I said, why not take those exemptions and write? And I wrote, and also 86 or 87, I passed my company secretary's exam also. So that's how it was there. And 88 to 90, I was in the staff college at Shimla, when government under the Colombo plan sent me to London for doing MBA for 1-year course at the University of Hull in UK. So 1991 also I did my MBA, completed it and got the degree. So everything I got was after I joined the civil service, except my graduation degree in physics. Everything else, the cost accounting or a company secretary or MBA, all of that was during my journey in the civil service. Then 91, I came back. Then I was a director of audit for the Railway Board and the Comptroller and Auditor General of India at Delhi. And 91 till 2011, I continued in Delhi for almost 20 years. I was in Delhi. 92, I was sent on deputation as a deputy secretary to the Ministry of Commerce. Then there itself, I got promoted as a director, and I continued there till 1995. And that was the time Uruguay round negotiations were just ending, and the entire thing was being implemented from 1994. And India did not have an anti-dumping working at all till that time, because we used to have very high customs tariff rate, 70%, 80%, 90%. Therefore, with that duty rate, the question of dumping or it affecting the domestic industry did not arise. But in 91, when we started reducing from 80 to 65 to 50 to 35, by the time I came out, it's almost 35, 25%. That started making an impact on the domestic industry. So anti-dumping directorate and correcting a dumping action became very important. So in 94, I set up the anti-dumping directorate and conducted the first 2 or 3 initial investigations was spearheaded by me at that point of time. Then in 95, I got my promotion as a joint secretary in the audit and accounts department. So I came out of the Ministry of Commerce, and I was posted in Chennai as a member audit board and the principal director of commercial audit, looking after all public sector undertakings in South India. So that's the last post. And of course, as I was part of that post at that time, I was also deputed to the United Nations to do the audit of the United Nations accounts. As you know, in the United Nations, all members contribute money and the United Nations spends the money. Therefore, that is being audited by 3 countries at any given point of time. And they have a tenure of 3 years. So during that period, India was one of the 3 countries doing that audit, which means that audit will be conducted by officers from the Indian Audit and Accounts Department. They will be deputed. So I was one of the team leaders for auditing the main United Nations accounts in New York. So in 1995, that's every 6 months, you have to go 6 weeks do the audit, complete for 6 months, and they have a 2-year account, biannual account that they call it. They don't have financial year, they got 2 years accounts. So every 6 months you go, and at the end of the 2 years, you give a audit report, which is placed before the UN General Assembly, and then whatever action is to be taken, take. So I completed that. So this is my journey. This is till about 1996 when I left to come out. That I will talk about probably the next, depending on your question. So this is my journey in the civil service.
So what a wonderful journey, I must say, because during this journey, not only did you did cost accounting, you also did company secretary and MBA from London, and this is while you are a serving bureaucrat, and with so much of responsibility across different states that you were transferred to, and you took so many important positions that you had to so many duties to discharge. Wonderful narrative, sir. In fact, you also mentioned about anti-dumping, and that you were one of the chart bearers and charter members of the anti-dumping authority. Sir, a very quick question before we start with the legal journey is that sometimes I feel that in India we have seen a lot of tribunalization, including anti-dumping authorities and everything. Do you think somewhere in India we can avoid the tribunalization and make it a part of the court proceedings itself, the main court hearing, and perhaps build specialist courts which can look into it? Why I ask this question is because many times, especially when the physical hearings are on, and I don't know what the future is going to be, but till the time physical hearings are on, it sometimes becomes very difficult for practicing lawyers to run from point A to point B. For example, if you have 5 to 10 matters a day across different fora, be it Supreme Court, High Court, or other tribunals, and so sometimes a better infrastructure, I think within the court with specialist court may help. I'm just thinking out loud. So what is your take on that?
See, there are two or two things. One is, as far as the anti-dumping directorate, which initially conducts the investigation, it's like a department. Like you have a commissioner of customs who decides the first adjudication. You have a commissioner of central excise service tax. Now you are going to be deputy commissioner of GST, commissioner of GST. So first is always a departmental proceedings. Yes. Once you cross the departmental proceedings, we talk about tribunal or court. I will come to that separately. So when you talk about the Director General of Anti-Dumping, as it was called, and now it's called Director General of Trade Remedies, because it is for dumping, it is for subsidies, it is also for safeguards. So you got all the trade remedies put together. This is called now Director General of Trade Remedies. That is a post within the Ministry of Commerce. So you have a quasi-judicial function being given to the Director General of Trade Revenues, and he has officers well versed in cost accounting and also in trade law, and they conduct the investigation. So at the first stage, it is always before a department of the government, or I call it before a bureaucrat, depending on the level, additional secretary, joint secretary, a commissioner, etc., as a joint secretary. So you are talking about at that level, you are talking about those adjudicate. It is beyond them. When you go, we talk about whether the appeals should go to a specialized tribunal, or should the high courts, etc., should handle all those things. I think those are slightly different questions. So when they talk about the anti-dumping, the first stage is there are a set of producers in India. They produce a product. They find that an identical product or a like product is being imported from different countries, and the price at which it is coming is a dump price, and that dumping is causing injury to the domestic producers in India. Therefore, they want the dumping to be corrected. So that exercise is undertaken by the Director General of Trade Remedies, and he comes out with a finding. And like any other, because it is a quasi-judicial, any finding is appealable. And that is why, because it has a relationship with the anti-dumping law, the subsidy law, the safeguard law, they are all under the Customs Tariff Act. Therefore, the appeal was given to the Customs, Excise and Service Tax Appellate Tribunal. So the tribunal specializing in customs is the one which is going to hear appeals against the order from the Director General of Trade Remedies. And not only that, considering the importance, they have also put a condition that the tribunal which hears appeals from anti-dumping should always be a 3-member tribunal, not a division bench like what normally happens, of which the president of the tribunal should always be present. So that is how they gave that importance to the trade remedy law. So to that extent, to answer your question, because all this arises under the Customs Tariff Act, and you already have a specialized tribunal for that purpose, that tribunal itself was made the appellate tribunal for appealing against orders from the Director General of Anti-Dumping or as trade remedies law. So to that extent, I think that is it. But after that, of course, you have to go any case to High Court or the Supreme Court only. Therefore, I think the courts have to deal with it. However, technical or the subject maybe, the courts have to deal with it, and the courts have, I think, dealt with them also. Yeah.
Thank you so much, sir, for that answer. Now, let me come to your legal journey. Being a bureaucrat and then having a switch completely, and your association with the Lakshimikumaran Sridharan, one of the leading firms in India. I think you have been a part of the firm for about 25 years, if I'm not wrong. You have been a senior partner heading the firm's Chennai office also for the past decade or so. So please tell us something about the transition. Was it difficult? Was it easy from being a bureaucrat and then hanging your boots and then joining and donning a hat as a lawyer? And also, so that our viewers know that sir, after joining and doing this transition of a lawyer, did his LLB from DU. We'll also discuss that when he shed some light on his journey from being a bureaucrat and then becoming a full-fledged lawyer.
Yeah, in fact, even today, when I look back, it's a little surprising that I took the decision and moved on, because having been for 17 or 18 years in the audit and account service, and right or wrong, I have made a name. I would have absolutely continued without any difficulty for my 34 years of service, and I would have retired at a secretary level in the government of India. There was absolutely no doubt. So it looks today also how I transitioned. It just happened that the first one or two anti-dumping cases dealt with, actually no one knew in India about anti-dumping, and Mr. Lakshimikumaran was a pioneer. Even that he took up for the first time. And he came to appear before the additional secretary, the director general. I'm only a director assisting the director general of anti-dumping duties, but as you are like more like the right-hand person doing the investigation, doing that. So during the personal hearings in those cases, Mr. Lakshimikumaran appeared. And then, of course, we started talking. And then he felt that it would be very nice if I could probably shift from the government to his side, and then the perspective and the career could be totally different. So that talk, that's how our friendship developed in 1995 when he started that. And finally, I took the decision, of course, with a lot of thinking, because you're absolutely assured. No pension also, because I'm retiring around 17 years, 20 years means pension. So I had, because I've shifted in between to the bank. So there was no question of continuing the service for 20 years. So 17 years, 18 years, no pension also. So without pension, and then of course the shifting was a very big decision. But what influenced me more was what Mr. Lakshmikumaran himself was an IRS officer of 1974 batch. And he was a deputy secretary budget in 1985 when after that he quit and started this firm, and he progressed. So that gave me a lot. If probably he was a career lawyer and he had asked me to come, probably I would have a lot more of hesitancy. But because he was himself a civil servant and he had come, of course, within 11 years, I had almost 17 years, etc. I think I had a lot more of comfort with him. And therefore, I think that took the decision, of course, my family supported, because you could always say as a civil servant, at least at the higher level of bureaucracy, you have a lot of respect in society. So people may look to that and then they may decide why you should see. But my wife or children, I think they were not, because I was probably in Delhi, I was staying in Pandara Road at that point of time. So if you think of that type of, stay in Delhi, you will not, when you go private, you have to leave all those things. So of course, there are always plus and minus in government. There is always prestige. There are other perks. When you're outside, you have other things. You probably have much more money, but you may not have the same prestige as you have when you are with the government. But that, I think, is a sort of balance. But it's, I would say, probably his great persuasive skills, which many people who know, including those judges who heard him, who argue, and my comfort with him as an IRS officer, so he could equate with me and also think how I would be thinking when I'm coming out, etc. It's, for example, like, as a joint secretary, you are used to a big room, etc., and you have a person. So you go to a law firm, you may have some one chair. So he even thought about it and made a small room for me so that I don't feel uncomfortable moving from a joint secretary. So those are the things. It's because and he had been a bureaucrat in North Block, so he could relate that, and I could relate to that. So I think that's how probably I took the decision. But for that, maybe it would not have been an easy decision. But that's how I took it. But then when I took it, then I decided, if I'm going to spend more of my life there, I don't want to be in a situation where I cannot appear in the court. I could appear in the tribunal right from the day I joined because I was cost accountant and a company secretary. That permitted me to appear before the tribunal. But I wanted to appear in the court. Therefore, I said I have to take my law. And that's how I took the entrance exam and joined the law center too at that point of time. And then passed out of the LC2 in 1998. And there also, I took the highest marks in LC2 at that point of time. So from 1998 to now, so 23 years now, I have my, after enrollment, it's 23 years that I've been as a lawyer.
Thank you so much, sir, for shedding that light. So now let me speak about your law firm journey, because bureaucracy, 17 years, and here you are arguing before the tribunals, and you have also now become a lawyer. And for viewers, I must also say that sir is also advocate on record, and he topped the exam when he took it. And it's one of the toughest exams in India if you want to be an advocate on record in Supreme Court. Sir will also shed some light on that. So, sir, starting with your law firm journey, how was the transition? Now you have started as a lawyer. You have to go to multiple courts, tribunals, argue, and you also have to not only be a lawyer, but also mentor a team of young lawyers under you. So how was that transition, and how different or how difficult it is to mentor young bureaucrats and young lawyers?
No, actually, to start with, there's no question of my mentoring anyone, because I didn't know much to mentor. I was to be mentored, but then the advantage I had was one, experience. Second is I came and started the international trade practice in Lakshimikumaran Sridharan, which was my forte as a director in the anti-dumping division. I started the anti-dumping work. So to that extent, I was the only person who knew the work. Therefore, I had to have one or two juniors with whom I will have to train and then do that work. But there are other subjects which I took where I always used to be a little apprehensive, because all others are well versed in the subject. If I talk to people who are doing excise, there are people at that point, service tax just started, but people doing customs and foreign trade policy, etc. I knew foreign trade policy because I was in the Ministry of Commerce, but my focus was very limited to certain areas, like deemed export was my specialty. Gems and jewelry exports was my specialty, but not the entire foreign trade policy, etc. It was not. You don't get that type of perspective. So one thing is, I knew all other people also had knowledge and experience and wisdom, and I should learn also from them. So the first thing is, I had to shed light that I was a bureaucrat, I was a joint secretary, and I will sit there and things come to me. I was very clear that should not happen. And that, I think, is the most important. If you think like that, it's simply not possible to work in a law firm or in a private sector. I think it's a totally different working culture, you could say. And it was quite a tough thing, because you are used to like 30 days leave, earned leave, you have a 12 days casual leave, and Saturdays, Sundays, there are holidays in the, I think, even though in the ministry, most of us, we used to work on Saturdays, but Sundays, we always did. But when you come to the law firm, it was all 6-day week at that point of time, 6-day week. And we had 5 closed holidays, if I remember right. October 2nd was not a closed holiday. Not a closed holiday. October 2nd was also not there. And therefore, it was Saturday. Up to Saturday itself. Starting time is all that we know. Ending time, most of the time, it is 9:30, etc. That's how all the people, not for me, for everyone. That's how I think all the people there worked, and there's no exception. It's not for Mr. Lakshimikumaran, it's not for Mr. Sridharan, it is not that they were playing golf or bridge, etc., and others were working. No, they were, even today, I think I still admire the amount of work both the brothers do as compared to what I am putting in. I think they are in a totally different league altogether. So they're therefore that work, but then if you are afraid of work, then you would not have come out. But even in the bureaucracy, you have to do a lot of hard work, especially at higher levels. You cannot stop saying something has not come. You have to get something going. You have to start initiating the work itself and doing it. Therefore, generally, most of the people in the higher levels of civil service are used to hard work. So hard work was not an issue, but still coming back from a 5-day week to a 6-day week completely. And then, of course, till 9:30 was a totally different experience. But then I don't think there was any problem, because you're always getting new cases, your clients, you're discussing with them, you are meeting deadlines, etc. So I think that it was a journey by itself. But the difficult portion was still around 6 o'clock from the office, I have to go. At that time, it used to be in ARST colleges where the LC2 is there. You finish your classes by 9, means most of the time 8 o'clock will be over. 6 to 9 is 6 to 7:30, 8 only. From 8 o'clock, you go back to the office in Southern Enclave, complete your all work, and then go home. So it was a very tough initial period. And Mr. Lakshimikumaran said it's not enough that you do only anti-dumping, which yes, you start, you build that up, but you should also have one more subject on your thing. So you kindly take customs valuation and specialize in customs valuation. Therefore, from day one, I started doing both customs valuation and the anti-dumping investigation. That's how my career started. And I think that went on for quite some time. Of course, subsequently, we have a lot of youngsters, their aspirations are different. So they wanted a 5-day week. So Mr. Lakshmikumaran also gave in, and we also have introduced 5-day week. But then all that it gives you is a flexibility. You still are working on Saturdays, not that you will be able to do without working on Saturday. It gives you flexibility. You come at the time which you feel comfortable, you do the work, etc., and go back. So those are things, but we had also the luxury of at any given point of time, there'll be like 3 or 4 stenographers in the office. People will be staggered. Some people will come at 8 o'clock in the morning and go around 4 o'clock. Some will come at 4 o'clock and stay till 10 o'clock in the evening, so that you can dictate, because most of the time at the time you used to have dictation, they will put it on the computer and send back to you, etc. But today that is no longer there, because those are very you don't find good stenographers. Everybody, including me, we start typing our own things, or you start dictating on the Dragon software or something like that. But most of it, it's a different experience. But at that time, we had the luxury in the first 5-6 years, etc. We had people to whom we can dictate, senior people. All of us were seniors, so we are doing the original work. We are also going to the court, and therefore, I think it was absolutely a very nice experience. Yes. It was very challenging, hard work, but I think if you're afraid of hard work, of course, nothing can be done. You should not be afraid of hard work. It takes you to a lot of heights. Yeah.
So it's a wonderful narrative of how hard work can change things, especially, I think at every juncture in your life. And from what I'm realizing, be it bureaucracy, be it now being a lawyer, you are also studying law while you are discharging your duties at one of the premier law firms in the country. So what prompted to become an AOR? What was the need? Because you had already cleared your LB, you're already a celebrated bureaucrat, and you're already in a, if I may say so, comfortable position in a law firm. So why become an AOR?
No, it was actually purely a request from Mr. Lakshimikumaran. He said we are engaging people outside in order to file all our Supreme Court appeals, etc. Why don't you write the AOR, and then we can have in-house filing it. So that's how it started. I said, okay, if that is so, I'll take it up. So in 2004, I wrote the AOR exam, and then got a first rank. That I got the gold medal from Mr. Sabharwal, Chief Justice at that point of time. So that is how. It's because of a requirement within. I said in-house we can have the AOR instead of having to go outside every time we have to file, because we have a lot of cases in CSTAT on valuation and rate of duty, both of which directly go to Supreme Court and not to the High Court. So we used to have a lot of filings in the Supreme Court. So it would make it easier if you do it in-house. I think that's how the request came.
Right. So my next question is, because now that you're a full-fledged lawyer, you've seen the bureaucracy, you know the modalities and the workings of the government. And as a lawyer, when you're appearing in CSTAT, even challenging orders in various high courts and Supreme Court of the country, how often would you come across colleagues from the bureaucracy? And because you have worked with the government, now you're challenging the government orders or government mandate. So how was this transition for you?
Yeah, in fact, the transition was the problem, as I said. The way I had dealt with, I have not had passed any orders, because if you're in the excise department, income tax department, you are passing orders which are challenged. But only to the extent of the anti-dumping, even though I did not pass the order, the Director General passed, but I was instrumental in doing that. So those are the first 3 or 4 orders. But subsequently, of course, all the people, till now also, people know me in the directorate, even after 25 years of living. Most of the people know me, including the present Director General of Trade Remedies, with whom I had worked in Geneva when I was arguing for Government of India against the United States in a WTO dispute. He was there as a legal officer, and now he's come as a DGTR. So absolutely no. In fact, on that, he's a pure professional friend. They will question me, how can you ask this deduction, sir? You know the subject much better, etc. But those are things. You try to convince them. Just like when I was sitting in the chair, they were trying to convince me. Now I'm trying to convince them and ask them to see my point of view. And of course, there are cases where they have seen my point of view. There are cases where they have not seen. If I'm unhappy, I have gone to the CSTAT. I had succeeded. I had failed also in some of those cases, then succeeded in Supreme Court, failed in Supreme Court also. So all these things are like a standard operating procedure. Okay, you have a job to do, you try to get it done as far as possible at the lowest level. If it is not, of course, you have to challenge. But anti-dumping orders are far more challenging to defend in the tribunal or in the Supreme Court as compared to your customs, excise, service tax orders, etc. Because it involves a variety of factors in anti-dumping, unlike the tax cases where I find are far more focused than with the trade remedies. There, the leeway for an appellate court is if the officer has done a reasonable job and the view is a reasonable thing, they generally don't want to upset that order unless it is really bad. So most of the time, we used to get relief wherever it was really due. In some cases where it was an absolutely correct case, but still, like it happens to many of us, we don't. I still say I like this profession as a lawyer because it helps me practice Bhagavad Gita to the core. Karmanyev adhikaraste. Your job is to do your job. Don't. Why? Because I will be going for a case today morning with butterflies in my stomach. What happens if this question comes from the judge? I don't have an answer. I don't know how. It doesn't go anywhere near. Straight, I get a relief. The next day, it's an open and shut case. I go. I don't know where it goes, off on tangent somewhere. Sometimes it gets adjourned if it is good. Sometimes it gets decided against me on a totally alien point, which is not correct also. That's but therefore it gives me clear. All that I can do is prepare well, anticipate various issues which can come from the judge, and try to put a defense for that. But after that, whether it will succeed or not, completely don't expect. So to that extent, I always felt this job for 25 years had constantly given me a slap saying, keep remembering Bhagavad Gita. That is definitely a great thing about this profession, according to me.
I think wonderfully put that, karma is the only thing that we can focus on. And karmandeva adhikaraste ma phaleshu kadachana is how the saying is, that don't worry about the fruits. I mean, that is an outcome which is up to the Almighty. And
why he placed that is still a mystery. There are cases which I have like that where I still don't know why such an excellent judge did not agree with me. And why in a certain point where I had difficulty, I thought that view may not be accepted, it was readily accepted. I don't have an answer to either of them. So that's how I think the life is.
Right. Sir, I have a follow-up question right from this. Because and I think you're the right person to answer this, because when you're appearing before a tribunal, and then there are times, as lawyers, we prepare to the best of our abilities, and then do the best of research, pleadings, drafting, and put it before the judge, and something completely unforeseen and what we may have anticipated may happen in our case, and the client suffers, unfortunately, and be that as it may, then we have no option but to challenge it subsequently, be it in High Court, be it in Supreme Court. But the problem that I'm sure you must have also faced in these past 25 years, and that I also face as a young lawyer, is that a lot of time is consumed in preparing these appeals, and then sometimes if the matter gets adjourned because the judiciary has a lot of pendency already. So how can we as a country, so to your mind, can improve? Definitely, there is a requirement of more judges. But I ask this question because you have been a part of the government, and perhaps you can shed some light, because I'm not a person with a great financial knowledge, but my basic understanding as a common citizen of this country is not too much of budget is allocated to the litigation or to the judiciary of this country, because of which there is a problem of last mile reach of justice to every person in this country, be it a business person, the biggest businessman, or be a commoner. So what can be a possible solution to this, so that the time spent in court reduces and people have more confidence when coming to their lawyers and even challenging an order that's saying that, look, we have a stipulated time, we have a time frame in mind in which this dispute is going to be decided?
Yeah, see, I don't know. It's a very, very difficult question. I think right from Chief Justices of Supreme Court from time to time have been discussing the pendency issues, etc. I don't know whether I will really be able to contribute much in that particular, because it's a very complicated issue. Not only one is budget, then the other is availability of judges. Then after that, also, right or wrong, the judges also have certain predispositions. So some of them are very comfortable in some areas, they are not comfortable in some areas. So if you put somebody in an uncomfortable area, generally they don't want to probably deal with it. They're not very, so you have a lot of such, things are at play. For example, what you said about time, I would say is very critical when it comes to the trade remedies law. The anti-dumping subsidies, they are valid for a period of 5 years. Okay. Now, I challenge an order as not be correct. Now, if there is no president in the CSTAT, then it can't be heard, because unless there is a president, the appeals cannot be heard. Now, by the time the appeals goes to the Supreme Court or something, obviously nothing is done within 5 years. So what you are getting is a fait accompli. And I have myself had cases where Supreme Court said, now it has become an academic exercise, therefore we'll dismiss this appeal and keep the question of law open. So we have that type of situation, because these are time bound. In 5 years, the commerce does not stop. For example, an anti-dumping duty is imposed. And I have said that the imposition is wrong. But every time an importer imports the product, he has to pay the anti-dumping duty.
Right.
So once you pay that, getting refund from the government, unjust arrangement, all that is almost impossible. We always give this example of getting a refund from the government is like putting the milk back into the udder of the cow. That difficulty is what you get the refund is. So you always have this, once you pay and thereafter you have the problem. After some time people said, sir, our business has to go on. We can't keep on waiting for that, etc. So many such things. Whereas if you are talking about one dispute in central excise regarding the classification, it takes, by the time even 5, 6, 8 decide, then at least I have follow-up of what is to be done. But there also, if something is decided by a tribunal against me, but till it is set aside, I have to follow what has been said by the tribunal. So in that period, things cannot be undone. How long can I say I will not pass on the extra cost to the consumer? If I pass on the extra cost, I cannot get it back. Then what is the point in pursuing the litigation? So you have a lot of such, but tax, I would still feel in the tribunals, at least my experience, they've been disposing of very quite fast. But the problem seems to be always like, I don't know whether you have seen on the 18th April, I also gave a small talk on the tribunal ordinance, and especially in the context of intellectual property, right? See, something you are also not giving adequate manpower to the tribunals in order for them to function. And I gave the example of the intellectual property appellate board having one technical member for patents and one judicial member. Now, if one of them is not there, the tribunal is not functional. And when you talk about patents, you have so many technologies. To have one technical member, if that technical member is in mechanical, he has no electrical, electronics, chemistry, etc. Why can't, as a country, such when four high courts, because you have 4 patent offices, 4 high courts at least a jurisdiction, why can't we have 4 or 5 technical members and 4 or 5 judicial members, so that even if there are vacancy in 2 or 2 of them, you can still constitute 2 or 3 benches and the matters could be heard. Right. But now it is going back to the High Court because of the ordinances abolished the IPAB. Now a single judge has also to understand the technology and then decide. And the decision is more important because a patent has a valid life of 20 years. And the 20 years life does not start from the date of grant. It is from the date of filing. So I have filed an application in 2010. It came to be rejected last year. Then I have to go to the court. If the court says what you did is wrong, you restore, and he restores it in 2023, 13 years of my life of my patent is lost already. And there are not technologies today which are really running for 13 years. The technology keeps changing so fast. An invention you have 4 or 5 years, if you have very good life and exclusivity, that itself is great. Except, of course, in new chemical entities for medicines, etc., new molecules, that will have a very great life. But most of the other improvements, they do not have a life of 5, 6, 10 years. So, but that is where I think both the intellectual property, where the applications, the life starts from the date you file the application, not from the date of grant. Even if it's grant, by delaying it 20 years, by the time you grant it, that technology has already been overtaken by some other technology. You don't get any benefit out of that particular thing which you patented. Therefore, it's very important, I would say, tax has got a lot of implications to the government. Therefore, the government will probably do something to ensure that tax benches function properly and disposals are taking place. But even intellectual property, etc., are very important from the point of view of business. And also, you are talking about exclusivity and selling ability, and your inventiveness. All those things are very important. So, for that type of thing, if there are going to be delays by going to the High Court, I think then again the entire purpose will be defeated. That's my and that's what I've said. That also we could have had. I have given the example of a European Board of Appeal where they've got hundreds of technical members, because today technology is so complex. Even if I had done physics, it doesn't mean that everything in physics I'll be able to do. No, my basic understanding will be there, but you require a lot more of in-depth knowledge in order to understand the technology and come to a decision whether it should be granted or not granted. So we are therefore I would say in certain areas the tribunals, according to me, the income tax appellate, the central excise custom tribunal, I think they have done extremely well, and that is because you have technical members and judicial members, and there are a number of benches. Because there are 5 or 6 benches, even if suddenly 2 technical members become vacant, you still have 3 benches to discuss and decide the cases. But whereas one type of bench, we are not. FERA, for example, earlier FERA and FEMA, the tribunal, lot of, I have 20 years before appeal still pending, not coming up for hearing at all because the tribunals are not functional. Therefore, the tribunalization aim was good, but finally at some point, I think manning them with proper people, etc., and doing it, I think that's where I think the implementation portion of it probably, I think we have not done it properly.
I think that that's a very, very good series of examples that you have given. And I also personally sometimes feel that perhaps I think certain tribunals can be done away with, and they can become now part of proper court structure, so that the whole idea of justice system is to give people justice within in a time-bound manner. I mean, and the way that you explain things, especially tax, custom, patents, and the way things are changing, and rapidly so, if I may say so, if a problem becomes only a moot problem before the court, then the business aspect that has to be treated at par with the jurisprudential aspect of developing law, I think, goes out of the window. I think so. That is I think a good takeaway from what you've just explained. Let me, sir, now take you back in memory lane to your again days in.
Only one point I wanted to add is, see, with the, coming into account of the Commercial Courts Act, we will still have to see. Again, it's good. It's again very good. The commercial dispute should be decided fast, and all that is there. But how fast, how good they are going to be implemented, and how well they are going to be implemented, I think we still have to wait and see.
Right. Thank you, sir, for that. I'll take back to you, sir, in your days in LKS, where you had just started and you were doing anti-dumping, and then Mr. Lakshimikumaran also asked you to look after the custom department, and then subsequently, I think you also took over the patents team. So how was that transition? Because you had already done BSc and you had a science background, and so far as Indian rules are concerned, to be a patent attorney, you have to have a BSc or at least a BTech to pursue. So how was that manning different verticals? Because you're already burdened with so much work, and then you had a new vertical to champion, and then your journey to heading the office in Chennai. If you can tell us something about that.
I know. See, one is from 1996 when I joined. Of course, I did customs valuation, customs classification, some foreign trade policy, and anti-dumping. That was my journey. Then, of course, things cannot remain stable. So I had also brought in some people from my own civil service friends, etc. I trained them, and then somewhere in 2007. There was, we had by that time started an in-house intellectual property practice. Earlier, it was separate in a firm called Kumaran and Sagar, which is now called K&S Partners. Mr. Lakshmikumaran and Jyoti Sagar were partners that sold K&S Partners. So intellectual property used to be with the K&S Partners, and tax alone we used to be doing in Lakshimikumaran Sridharan. But in between, intellectual property was also brought in within the fold of Lakshimikumaran Sridharan. And in 2007, when the person who was looking after it had wanted to go out, Mr. Lakshimikumaran said, why don't you do that? Because you also have a science background, why don't you take it over? And that's how I came to that. Till then, as I used to tell him, I knew only what is the spelling of patent. Other than that, I didn't know anything of the patent law or design law or any of those things, apart from what a little you studied when you are doing your law. That's all. Trademark you do, but you never do patent and other things even in your law college. So we don't know anything of that. So, but of course, because that is a full-time thing, by that, then I have left completely the trade remedy portion and also the customs, etc., except some important cases which I had to argue. I had argued cases in Supreme Court in 2000, 2003, 3, 4 on customs valuation. Many of those cases I have argued at that time in Supreme Court. In 2007, therefore, I completely took over the intellectual property practice, but I had some excellent assistance in the sense that Mrs. Malti Lakshimikumaran's wife, Dr. Malti Lakshimikumaran, was a scientist, and she had the complete technical background, and she was also there in that. And we started working on that. I was looking into more of the organization or also on the litigation and contentious issues, and she was taking care of all the other filing and prosecution issues. So that's how I came. Of course, you learn on the job over the period of time, and then so it's 2007 onwards that I've been continuously handling till 5th of April 2021. I was involved in intellectual property. So in Delhi, when I was there, it was only intellectual property. And after 2007, I was not handling customs and other things because, as you said, it's not possible to handle all the verticals. That's simply not possible. 11, there was again a requirement for to man the tax litigations in the southern regions, Chennai and Hyderabad. So I took a dual role actually. I was stationed in Chennai, but I was looking after all the complete tax practice in Chennai and Hyderabad, and I was continued to be associated with the IP All India. That is how from 2010-11 to 21 I was doing it. Therefore, I used to be almost like 15 days I used to be in Delhi and 15 days I used to be in Chennai. That's how it used to be. Are you able to hear me? Because I hear,
Yes, yes.
see you are frozen.
No, there was a minor disconnect,
Okay.
so now I can hear you.
Okay. Okay. So that is how between 2010 to 21, I was heading intellectual property for All India and tax consultancy and litigation for Chennai and Hyderabad, but that was my role. So I used to argue cases on, that is the first time I started arguing cases on excise, service tax, etc., which I have never dealt with when I was in Delhi because my specialization was customs, foreign trade, and trade remedy. Here, because it's a smaller office and you have to handle all the litigation, it came to excise, service tax, and all other areas as well. But I was continued to be associated with intellectual property and again contentious issues, pre-grant oppositions, post-grant opposition, revocations, infringement litigations, a counterclaim for invalidity of patents, all those things which are in the nature of litigation, I continued to handle it. And I had a team of people sitting in Delhi. And we also developed a small set of people in Chennai also for intellectual property so that some basic work can be done here. So we had a set of people here. We have people in Bangalore. And of course, the main team was sitting in Delhi. So that's how the intellectual property practice was also being handled. Yeah.
Sir, I have a follow-up question from this, mainly from the perspective of law schools. In law schools today, sir, and I speak for both the 3 years and the 5-year law courses, most of these subjects are not taught or are either not taught in detail. For example, intellectual property may be a subject, but custom, excise, indirect taxes, anti-dumping, so those things are not taught, and these have a huge commercial repercussions in any economy or for any country, and law plays such a major part. So, sir, what would be your advice to colleges or to law schools in the country or to young students who want to pursue this as a career? How to go about it? One option obviously is to find an internship in one of the leading firms, but then, sir, you know it and I know it, it's very difficult to even get an internship because it's highly competitive. There are limited seats for an interns. So what is the way around to teach people about the importance of these subjects so that by the time the breed of lawyers which hits the market is at least ready to embrace with the basic technical know-how of these subjects, and then the time which is spent in training such lawyers is minimized and they can be really hands-on when they join the law office?
Yeah, I think for that, I'll probably forget excise and service tax because they are no longer there. So today, when you talk of tax, you will have income tax, you will have GST, and you have customs, 3 areas. And whenever we talk of law college, we talk, a tax means income tax. That's generally whatever little is taught is only on income tax, nothing. So I think definitely they must have a curriculum for GST also. and also for customs law. I think without that, because then you at least know the basics of the the difficulty. No one used to know about excise, service tax, etc. They have to start from the scratch after joining the law firm. If you are, as you rightly said, if you are able to get an internship, and then you build up over that 4 weeks, 6 weeks, you have to build up your knowledge and then continuously do. The one I find is the Chartered Accountants Institute.
So your experiences about the GST in the law school curriculum when there was a minor.
Correct. Now, I feel that just like what you have in law, at some point of time after you have had the basic law subject, you are given some subjects to elect. People have to give the option of tax as an election, and in that it should not stop with income tax. It should definitely do with the definitely GST, because that is all pervading now. Therefore, GST, customs. Some people, if they are interested, maybe they take it up. If they find all the 3 subjects are difficult, at least GST and income tax, if it is done, and then the 5-year course, people coming out of it will definitely have the basic knowledge about the taxation. And then, of course, they can always build the practical aspect through the 2 or 3 internships which they get before they complete, and thereafter they can join. But if they don't have a GST as a subject also, then I think to start from scratch during internship, that also just 4 weeks, etc., it's not going to be easy. So they have definitely to teach this particular. Therefore, people should be allowed to take different modules as electives. If you want to specialize in intellectual property, and mainly, for example, if you have some law, 5-year law courses which are doing BSc honors and LLB, then those people are ideally fit for patent work. Then they must have special modules so that they can go a little more deep into the patent law and come with a much higher level of knowledge than other lawyers, so that they can start work on in this particular area. So I think that is definitely the curriculum has to be molded. And I was saying when our connection got disrupted, the Chartered Accountants Institute did that very well. So they were the ones who found out the importance of indirect taxes. And in their curriculum, they very specifically put excise and service tax, and they kept it, even though it may not again be very high level, but at least people knew what the excise law was about, what the service tax law about it, and now you have GST. So I think that the importance for tax has to be given in the law schools. It must be taken as an elective subject, and it should not stop with income tax. It should definitely get into GST as well. Then I think you will have both the direct and indirect tax you have. Then people can say, okay, I go to direct tax. Indirect tax, also you will go into transfer pricing, you can go international transactions. There are so many areas to specialize, but at least you will have the fundamentals ready. All that you require is a strong fundamentals, so that you can build on it with a practical exposure when you come to the law firm, and build as quickly as possible a higher level. That's, I think, what is required. I would definitely say it is required. And then most of the law schools for this subject should take practitioners. Yes. And give them to develop a module for, let us say, 10 or 12 classes of 2 hours each, so that it's like a crash course on that particular tax. And people who are really interested should come to the course, because after that they can study on their own and build it on it. I think that's a very important thing, according to me.
I think that's a wonderful session, sir. I hope this reaches out to even law schools later when the video goes live, and also perhaps the Bar Council of India, which is the regulatory body for designing the curriculum for most of these law schools, because I think the need of the hour is to prepare the lawyers, the future lawyers, for things that they have to embrace in profession, and not just be academic when they're learning. They must also, a little bit of pragmatism is also there. Sir, I have a follow-up question, because you spoke about GST. There is a criminal prosecution which is also attached to the GST Act. Do you think it's right on behalf of the lawmakers to attach a criminal provision in a tax law like this, or do you think they could have done away with the criminal prosecution part in GST?
In income tax also there was a criminal prosecution. Customs also there is a criminal prosecution. Excise also, service. It's not, because then what they kept as a threshold is, for example, tax evasion beyond 1 crore. There they kept the discretion for going for criminal prosecution. So there are cases where there are 10 crores, 20 crores, 30 crores, 200 crores demand also, but they have not gone for criminal prosecution because there are interpretation issues, etc. involved. Therefore, till the department says my interpretation means you have to pay 200 crores. I say my interpretation. So it is not like a smuggling or something like that where you need to take that. So what is important is the provision, I think, throughout the world, there are both civil penalties and criminal penalties in tax laws. It's not. But how we use them and how we administer them, that is what is important. See, there are cases, for example, people collect the GST, but they don't deposit with the government. So that's a very big thing. You collect the money from somebody, but you are not even depositing. See, suppose I have not collected GST thinking whatever I do supply is not taxable. But you now come and say it is taxable, therefore you avoided tax, etc. To say to that sort of thing, to take for a criminal action, maybe. I think that is where the senior officers have to be very circumspect and careful in launching criminal prosecution, because criminal prosecution has a lot more of consequences, and the time that goes parallelly. Sometimes the civil ends, but the criminal doesn't end at all.
Yes.
And you might have been completely exonerated in the civil side, but still on the criminal side, you don't get exonerated, despite the fact saying that the threshold of requirement in criminal is much higher than the civil. And in civil, the lower threshold is not met and you're left. How can you go for the criminal side, etc.? So there are issues like that. Therefore, having a provision for criminal prosecution in appropriate cases, I think in the statute, it was always there in the earlier direct, indirect, also, it now also, I don't. It's all a question of use or misuse as the case may be. What we are reading is, because of this provision, some cases of gross abuse of power in arresting some people and putting it, that is where I think the problem comes. Therefore, it's all a question of throwing the baby on the water. So it has to be, that is why the power is given to senior officers, and they have to be very, very circumspect before, because it's a personal liberty of a particular person. And is there a reason to arrest them because they will fly away or something, etc., then that's a different issue altogether. So my take is, yes, provision will definitely be there. It is again, put them in very strict conditions and ensure, unless and until those conditions are really met, you don't arrest people and take the liberty.
Thank you for that answer, sir. My follow-up question is a little bit on patents, and considering how the scenario is, we are suffering from the tsunami of this pandemic. And I think of late, I'm reading a lot in the newspaper that central state governments and even certain agency and authorities in the country are requesting for the patents war to be abated amongst the countries, so that a vaccine can be developed and rolled out to people across the world over. And so far as intellectual property right is concerned, countries, especially I think US is there and other countries are there, where the request has been made time and again that please do not impose patents, or it will put the cost of the vaccine or the vaccines which are yet to be launched to a very, very high cost, which some people in less developed countries may not be able to afford. So, sir, what is your take on that, and what can be a solution to this problem, and how can we put vaccination at a power price which is beneficial for common man also? Right, please.
See, I have, of course, certainly some amount of information. I don't know whether I have complete information to answer that question. But what I understand from the reading is, one is, we are talking in the WTO regarding the TRIPS waiver under the trade-related aspect of intellectual property rights. All of the WTO members are obligated to give patent protection. And of course, we have certain exceptions. One of them is the health emergency, which is what India and South Africa are invoking, which was also earlier in the Doha Declaration on health emergency also was there. And we are seeking waiver. But what by that waiver, what if suppose Moderna or Pfizer have a patent for their vaccine, let's say in India, obviously no one can manufacture without a license from them if their patent has been granted. If no patent has been granted, then of course they can't go for a suit for infringement till the grant of the patent, but they can recover reasonable royalties once the patent is granted from the date of publication of the patent till the grant. So here, whether, because these are all very latest inventions which are going on, because the pandemic started last year, it's very unlikely that a patent would have been granted in any countries. So what I understand the major problem is, even if we say that we are granting patent waiver, actually you'll still not be able to manufacture in India because you require know-how. What you really require to manufacture the vaccine is the technical know-how. And therefore, it is not the patent, it is really the know-how which is more important, is what the general arguments have been going on. And that's what I think some negotiations and discussions are going on the WTO. So one is, if there is an existing patent and because of an emergency, you want to give a compulsory license for that patent, or you want a waiver of the monopolistic rights, that's one thing which will enable somebody else to automatically do. But here it looks like it's not even that. Even if that is done, you may not be able to manufacture because the technology of mRNA, etc., is probably not well known for people to synthesize the vaccine in India. So we are also talking about two things. One is technical know-how, even after a patent, to manufacture the vaccine. And therefore, I think negotiations are going on.
Thank you so much for your answers. We have taken a lot of your time, but before we close and come to an end to this program, I always ask for the closing comments from our guest, especially for our young listeners. And when I say young, I just don't mean youth, I mean people who are young at heart and young in mind. So what will be your closing comment and suggestions for us?
My closing comment is what? Every profession is excellent. Every profession has its ups and downs. And I think the legal profession is, after seeing it now for 25 years and having been in 18 years, it is a great profession. And it's a great leveler. That's what I find when you're walking on the corridors of the court. You are not a senior, junior, anything. You just walk around the court, lunch, you all sit together, eat. I think it's a great profession, and also enables you to keep calm. Of course, all of us get affected when you know a case has to be won, you don't win. You always get affected. I don't think anybody is an exception, because we all have not progressed to that level of equanimity to be like that. So we'll be affected, but you just have to drop that, get going. And for that, I think it's a very great profession. But like every other profession, hard work and definitely a certain amount of luck are required. Sometimes people say hard work itself brings the luck, but you still do have to have that break. So all the best to all of you. I think everybody can do well, and especially now with India, excellent law colleges, the 5-year law colleges, and I'm seeing in the moot courts, etc. also extraordinary talent in young people whom I'm seeing. So I think there's a great future for the legal profession in India. Thank you very much.
Thank you, sir, for connecting with us and taking time out of your busy schedule. And to all our guests, we always request you that if you like our channel and if you think we are treading the right path towards generating some legal awareness in the country and internationally, please do like, share, and subscribe to our channel. And on that note, sir, I wish you all the success, health, and best wishes. And I hope, sir, this tsunami of Corona is behind us and we are able to meet in person someday very soon. And for your wonderful next chapter in your legal journey, I wish you all the very best. And until next time, see you soon.
Thank you very much. Even this will pass.